welcome you all to this special lecture. It is the third of our special lecture series, which is called Land, Housing and Property Rights, Tracing Policy Shifts and Emerging Issues in India and the Global South. This is a very special set of lectures and seminars that we have curated as a collaborative effort between the Center for Urban Policy and Governance and the Omidyar Network India. The purpose of this series is to create an interdisciplinary dialogue amongst academics, scholars, practitioners, activists, as well as policymakers. The point of these lectures is to discuss contemporary developments related to, as well as ongoing experiments in making land and housing more accessible and inclusive for all, and to address themes related to land rights for marginalized urban groups, especially issues and challenges of real estateization, and whether we can think about commons as a way of contesting commodification of land and formal and informal land markets in the global south, as well as to really theorize land and social relations around land. So we welcome you all to this special set of lectures. Today's is the third one. We've already done two, which was on the Jaga mission and looking at the titling of land rights in Odisha, the first two lectures. And the third one today is on RERA. I would like to now hand over the proceedings to my colleague, Smita Vengankar, who is a research officer at the Center for Urban Policy and Governance. She has a deep interest in housing issues, is a housing activist herself, and she is also a PhD scholar working on housing and land issues in Maharashtra. So welcome, Smita. Please take it forward. Thank you.
Thank you, Ratula. Welcome to all in today's seminar on maximizing the potential of RERA, a policy practitioner's perspective. The Government of India introduced the Real Estate Regulation and Development Act RERA in 2016. Under this law, all the states were expected to establish a regulatory authority to deal with the issues arising from the transactions in the real estate market. The establishment of a RERA, a regulator, was intended to ensure accountability towards the property buyers, protect their interest, bring in transparency in transactions, reduce delays in project handover, establish a fast-track dispute mechanism, and boost investors' confidence in the real estate market. From the buyer's perspective, who are in a vulnerable position, can make this best use of a RERA rules or law for claiming and protecting their rights. So RERA can be seen as a much needed intervention from the government in the highly unregulated, complex, competitive, dynamic sector like real estate market. The implementation of RERA is an ongoing story. I can say that story of a challenges, incompleteness, gap. So what is intended and what is actually happening. Its implementation has been uneven across the states. In the second year of RERA, the regulatory authorities, including the Supreme Court, compelled the states for setting up the RERA official website and disclosure of the project information. To mention the noteworthy events of the RERA Act all over the India, the contribution of a RERA Maharashtra, that is MahaRERA, is praiseworthy. As per the reports published in the first of 2019, among the 43,208 RERA projects, registered RERA projects, almost half of that, 21,742 are registered with the MahaRERA. For solving the disputes, the UP RERA took an active role. Among the 20,000 settled cases, UP has the highest number of cases, around 6,000 settled cases. As for now, 29 states and union territories have set up RERA authority, among which 9 are under the temporary authority and yet to settle the final set of RERA rules. It's very interesting to see the developer from the side of a developers, the perspective of them. In quote, RERA is a game-changing regulation for the real estate sector, but it is marred by the patchy implementation. We are seeing new real estate projects slipping through the regulatory net. GST application is another challenge. So MahaRERA is regarded as a role model for effective implementation of a RERA with the many innovative initiatives and through an ISO certified by paperless and zero-footfall automated offices. Our today's speaker, Mr. Gautam Chatterjee, who was tasked to set up MahaRERA. He took over as chairman of a MahaRERA and served till January 2021. We are really grateful and having him today as a speaker for this seminar. Mr. Gautam Chatterjee is from IS 1982 batch, a gold medalist in MSc Mathematics from Patna University. He also holds a PG diploma in urban planning and housing from the Netherlands. In his illustrious career spanning over 33 years, Mr. Chatterjee has held several important assignments both in Government of Maharashtra and Government of India, such as CEO of MHADA, Maharashtra Housing and Area Development Authority, CEO of a Slum Rehabilitation Authority, SRA, and Principal Secretary of Maharashtra Housing Department. After his superannuation, he briefly served as the OSD, Officer on Special Duty, to the Chief Minister of Maharashtra, where he was tasked to set up this MahaRERA. The successful MahaRERA Conciliation Forum is one of such initiatives implemented by Mr. Chatterjee. So welcome, Mr. Chatterjee. We are really eager to listen you on the overall implementation experiences, learnings about the RERA across the state. Very much interested to listening what were the challenges to institutionalize MahaRERA. Also your opinions, your remarks about overall framework of a RERA as a policy, as a regulatory system vis-a-vis growing demand of affordable housing. I also welcome Dr. Amita Bhide. She is a professor and dean of School of Habitat Studies, and she is a discussant of this seminar. So I request Mr. Gautam Chatterjee, so please start his presentation.
Thank you, Smita ji, Dr. Amita Bhide, Dr. Ratula Kundu, other members of the faculty of this, and all esteemed participants in this third lecture series. I was just told before the others joined in this session by my friend Amita that there are students of urban policy governance and regulatory governance who would be very much interested and find this topic interesting. But there'll be others who would find a little dissociated from this topic of RERA because that may be a technical subject. So I will try and see if I can make it interesting for even others who are not pursuing their studies related to urban policy, housing, and related topics. But then each one of us, I believe, at some point of time would aspire to buy a house, and therefore would require that we understand what this new act is all about. So with that brief introduction, let me just share the screen so that I can make this presentation. And yes. So I hope the screen is visible to everybody. So what I'm going to present today in the first 40-45 minutes would be maximizing the potential of RERA. So RERA, which is the short form for the Real Estate Regulation and Development Act of 2016, which actually came into effect, all the sections of the act came into effect from May 2017, 1st May 2017. Though the act, certain sections of the act became applicable from 1st May 2016, essentially giving 1 year period to the state governments to set up the regulatory authorities in every state. And while I speak about RERA, what was there prior to RERA coming in, what were the problems, how essentially the Act tries to see that those problems which were there in the pre-RERA regime gets resolved. And then moving on to share your experience with my experience as the founder chairman of MahaRERA as to how we try to understand the Act and implement the Act, and what are the challenges that still remain ahead of us.
नीतूचा नंबर आहे नीतूचा नंबर
May I request participants to just put off their mics so that I don't have any distressing signals. Thank you. So as I mentioned, my presentation would be divided in these, as I have mentioned here. First is, of course, what was pre-RERA, what was the state of real estate in India, how important this real estate sector is in the country, but then how it has taken us 70 years to bring it under a regulation, a regulator. What are the three Ts, as I often mention, as the important three aspects of three Ts of RERA, and what are the 5 key pillars of RERA? That's I'm going to explain. What were the things that MahaRERA did? Why is MahaRERA looked upon as a role model for RERA implementation in the country? So the pre-launch preparation that was done will be interesting to share with you, because whenever you plan out a thing properly, then it turns out to be successful. That's what essentially it means. I'm also going to share the RERA implementation progress report across the country as to how it has been implemented. As Smita just now mentioned, that there has been patchy implementation. It's not a uniform rollout across the country. I will also analyze some of the statistics that emerge out of the MahaRERA's performance in the last 4 years as to how RERA can be said to be certainly a game changer, and what things come out of these statistics. Some of the innovative initiatives of MahaRERA also I'm going to share. And then, of course, I'm going to end my talk with what will be the challenges in this RERA regime post coming into effect of RERA. Now, what was the situation of the sector prior to the Real Estate Regulation Act coming into effect? Now, when I said that each one of us, every participant here or everyone who has access to today's proceedings, will have to understand and know and be interested in this, because at some point of time, each one of us would be looking for some sort of either an office space and certainly some roof over our head, as maybe a ownership housing. Even people who are already having a house in their name, maybe at some point of time would require a second home. So now, what was there prior to 1st May 2016, prior to this act coming into effect? The sector was completely unorganized, unregulated, with multiple challenges. Let me just share with you some of the challenges that were there. Now, the most important thing which I have always mentioned was information asymmetry, meaning that if suppose I, as a home buyer, I am putting in my lifetime savings to buying a home, which in fact maybe only once in a lifetime I should be able to muster courage to buy, because real estate is so expensive. And I try and get into a project, I put in my money, I book my home, and I keep on waiting for my home, and I keep on looking for information as to what is happening to the project in which I have put in my money, and I don't get information. Now, this is in spite of the fact that in Maharashtra, in 1963, way back in 1963, an act was there called the Maharashtra Ownership Flats Act, in short called MOFA. But then MOFA was mostly on paper, because essentially many of us did not know, one, and two, MOFA also required a real estate developer who has taken up a project, who has taken bookings from common men. He was required to share information. He used to never do that. And therefore, information was just not available. If you go to the project site, you will find someone sitting there as the site engineer. You want to get information out of him. He has half-baked information. Whatever he gives is not in tandem with what is actually happening in the course of the construction or the slow pace of construction. So information asymmetry, and related to that was the sundry abuses that used to happen. I put in the money, the project does not see the light of the day. or something else happens, and if it is a fraudulent developer, he runs away with the money, he puts that money that I have put in project A, he utilizes that money to expand his business to buy project B, C, D, and so on. So that was the first challenge. Second, we all know that the private sector, who actually are constructing the bulk of the housing, were catering only to the upper middle class and the higher class. It was expected when the various state governments created the so-called housing boards, the likes of MahaRERA as we have in Maharashtra. It was expected that affordable housing will be constructed by these housing bodies, which will have access to maybe subsidized land, because land prices are so high that if one has to buy a house which is at the market rate, then it is beyond the affordability of the lower income group, the economically weaker section. At one point of time, the total housing shortage in the country was assessed at around 1.9 to 2 crore, of which 95% was pertaining to the economically weaker section and the lower income groups. Now, why was it happening? Because all these so-called housing boards put together did not have the capacity to bring in that, to come up to that scale where they can uh, give that many houses as are required. So the supply was very much limited and the demand was huge. Now the private sector was not in that, because private sector was only catering to the middle class, upper middle class, and the higher class. Therefore, affordable housing was not available. Public agencies were lacking the capacity, and therefore there was limited choice for the consumers. If you had the money, you go ahead and you book it, and then you don't get information, and you are always struggling to know as to when my house will get completed. And that brings to the last point also, the huge delays. I kept on waiting for my home to get completed, and it is not getting completed. The sale transaction documents, starting from the booking letter or the booking document to the agreement for sale, which brings into a legal contract with the buyer and the seller, between the buyer and the seller, that was also not standardized, not being followed in a proper manner, and hugely lopsided in favor of the developers. And a result of all this was a trust deficit. That means you are buying a home, which is your all lifetime savings, from a person where somehow you feel that I cannot trust him, which is a very, very dangerous thing to do, because you are buying a home and you do not trust the person from whom you are buying. And whenever you have a problem, you do not have a proper forum where you can get your grievance redressed. So this I would put as the multiple challenges which were there in this sector. And the sector we are talking about is the real estate sector. Now see how important is this sector vis-a-vis the total country's economy. It contributes to around 6% of the nation's GDP. It employs around 4 crore, if not more, workforce. Though majority of this workforce, I would say 80% would be unskilled laborers in this. But then it's a major employment provider next only to agriculture. Apart from this, it also ranks third in the total effect it has on the various other industries, because there are so many other industries: cement, steel, paint, brick, building material, and you name it. All of them are dependent on this real estate industry. And as I mentioned, now it's not only that states in the country are urbanizing. Maharashtra is one of the most urbanized states, but it is expected that Maharashtra is already more than 52%, 50% urban in Maharashtra. But then across the country by 2050, more than 52% of the India's population will be expected to live in the urban areas. And when you start living in the urban areas, obviously, apart from those who are the unfortunate ones who do not find a roof over their head, so therefore they have to stay in an informal settlement, as we call slums. But then one would expect that with the various policies of the government of India, there'll be many more affordable housing that will be available in all these urban areas. And each one of these people who would move into the urban areas would be requiring a home, and therefore would require the knowledge of RERA as to when they are buying a home. Now, as I mentioned, such an important sector with so much of contribution to the GDP, to the workforce, to the employment, and other things. But then it took us 70 years after independence to realize that this sector cannot remain unregulated, unorganized, and therefore has to be brought under regulation. And that's how, in 1st May 2016, we had the Government of India notifying the Real Estate Regulation and Development Act, RERA, we will call RERA henceforth. So it essentially states that all commercial and residential real estate projects, including plotted development, because may not be in Mumbai, but then outside, there are people who intend to buy plot and then they will construct their homes on their those non-agricultural plots. So all commercial residential real estate projects, including plotted development, shall have to be registered under RERA with the respective state regulatory authorities. Now, it also said, very interestingly, because there was huge pain in this sector, prior to 2016 also, there were umpteen number of projects, thousands of projects, which were launched, but were in the incomplete state. And as I mentioned, there were delays in their completion, there was information asymmetry. But then it was very good to understand that the parliament felt that these projects which are still incomplete should have to be brought under the ambit of RERA, because the RERA would then try to see how through regulatory mechanism, those unfinished, incomplete projects can also be taken to the logical conclusion of completion. So therefore, new projects that will be launched post 1st May 2017 certainly would have to be registered. But even those projects which are earlier projects, the legacy projects with problems, with no problems, will also have to be registered under the provisions of the Act. It very clearly stated that no promoter or a developer shall advertise or market or book or offer for sale any such apartment or a plot or a building or whatever it is or part of it without registering the same with the concerned regulatory authority, which meant that if a person does not follow this, still goes ahead even after the launch of the Act, goes ahead marketing his plots or his building that he is constructing without registering, then there are huge penalties also in the Act. This RERA authority that was created was very interesting in the sense that it was tasked to do three types of functions. First, of course, is the administrative function, where such projects which require registration to be registered. If they don't register, then penalize them to see that they come forward and then register. Then the second part is the quasi-judicial, where you hear grievances of people who have some problems from the projects in which they have booked into. So in registered projects, there are people who have problems. You should be able to actually come out with a prompt grievance redressal mechanism. So that is the quasi-judicial function. And it also has an advisory function, where the respective state governments or even maybe the central government would require this regulator to give them some advice which are pertaining to this sector, that is urban housing sector. So this is basically what was brought in through the ambit of the Act. And MahaRERA, with its pre-launch preparation, which I'm going to explain in a very short while, was the first to launch this web portal on the midnight of 30th itself, because it said that though 1st May is the designated day for starting of the Act, but since it's an online proceedings, it must start on the midnight hour at 12 midnight, and that's how it started with a 100% digital platform. Now, as I mentioned, that I keep on saying that let us try and understand what is the basic objective of the Act. Now, certainly the objective of the Act has to go back to what were the problems in the sector. Is the Act trying to resolve those problems, address those problems or not? And I feel that from that comes out, it may not be mentioned so in the 92 sections of the Act, but then it can be certainly put under these three Ts. The first T, of course, and the most important one is transparency. The transparency will remove that information asymmetry and the opaque practice that existed in this real estate sector. And how is it that going to be removed? It is through online disclosures, which will be available in public domain. Now, what happens is that disclosure, which where in fact it is available in the public domain, is one is not dependent on someone to get that information out, because you can that access that public domain and find out every information that is going to help you to make an informed choice. So basically, this transparency not only removes information asymmetry and opaque practices in the sector, but then also empowers a citizen, empowers a home buyer or office space buyer to make informed choice, because he is not dependent on someone to tell him, why don't you go to Mr. A, he's a good developer, and buying it from there. He goes to the website, the web portal, checks out for himself as to what are the projects, what are the salient features of the project, and then makes an informed choice. So that's the first T, transparency. Second, as I mentioned, that there was a huge trust deficit. It's going to take time for this trust deficit to get bridged and gotten removed. But then this trust deficit between the promoters and the buyers was something which made this sector very unsustainable. So if you want to make this regulated sector sustainable and forward looking, then you must have to build trust. Now, trust building cannot only happen through a speedy grievance redressal through quasi-judicial mechanism, where a problem is faced by a person, he raises a complaint, the complaint is actually advocated by an advocate, the matter is heard as is heard in a court. The only thing is that you do it faster than it happens in maybe a consumer court or a civil court. That's one part of it. It's certainly necessary and it should be done as quickly as possible. But then what was realized in this was that the Act also had a provision by which there was a possibility of a mediation and a conciliation. Whenever there is a problem, if the two warring parties can be made face to face, sit face to face, and talk to each other to see whether there is a way ahead in resolving that problem in a mediatory and a conciliatory manner, then why should it not be done? The Act had taken cognizance and had also made a provision for that. MahaRERA was the first RERA to latch on to this provision, and it turned out today it's the most successful forum, which has also been discussed in the UNCTAD as one forum where about 75% of the cases, 3 out of every 4 which goes in conciliation, gets resolved in a successful manner. So this was building trust. And the third was completion of the project in the stipulated time. So timely completion was the third T. And that is why RERA required not only new projects to be registered with a stipulated timeline, but it also required old projects where maybe the timeline had already expired. But then it required them and gave an opportunity to those builders to come forward to say, okay, your timeline may have been 2015 or 16, it's already expired, we are in 2017. You must register now and give a fresh timeline by which you will now intend to complete the project. And that timeline that you give, which is the fresh timeline, has to be commensurate with the balanced development work that is remaining. Essentially meaning that this provision was brought in to see that you give that adequate time to every project, be it the old, stressed, stalled projects or the new projects, to see that they get completed. So these are the 3 T's, which are the basis for the Act. And these 3 T's are sitting on the 5 pillars, which I say, of the Act. First, of course, the transparency I've already mentioned. So that is one T, which is also there in the 5 pillars. Second is fiscal financial discipline. The financial discipline was another thing that was necessary. As I mentioned earlier, what used to happen is that a developer would pick up money for a particular project, but then he was not honest in utilizing that money for the same project. He had ambition to expand his business, and therefore he would go ahead and buy land somewhere. And therefore, if liquidity goes away from the project for which the liquidity is meant for, then that project certainly gets delayed. So this Act required fiscal discipline in the sense that 70% of the money collected from the buyers will have to be perforce utilized for the construction and completion of the project. And that money cannot be spent elsewhere. And this has to be overseen by 3 professionals: the architect of the project, the engineer of the project, and a chartered accountant. So this was a very important aspect of this Act, which ensured that the money would remain in the project to ensure that the project gets completed. Accountability, another very important thing which usually is missing in variety of sectors and due to which many problems are faced by each one of us. So here it brought in accountability among the most important stakeholder, which is the developer and also the real estate agent. Though in fact the act I would have preferred goes on to create this sense of accountability among all stakeholders, because there could be also a landowner, there could be an investor, there could be a financier, a bank. No, there are variety of things which come in and which put in money or land to make this project. And of course, there will be government agencies who give variety of approvals or maybe don't give. So essentially, accountability is something which I think as we go ahead, maybe there'll be amendments in the act which will try and bring in accountability among all stakeholders in a real estate project. Compliance is most important because the act requires that there are certain things that a person should do. The do's and don'ts of the act have to be complied with, and if not, then there are serious penalties for the same. And all this is based on the Kendra Bindu, which is the customer. So it has customer centricity to safeguard the consumer's interest. In order to do that, all these things are built around this. So these are the 5 pillars on which the act is. Now, let me also quickly take you little detail when I say that what these things entail: the citizen centricity, transparency, financial discipline, accountability, and compliance. Now, it entails that when a project where you are looking at a project to see that should I put in the money there, should I book a home there or not, you should be able to see all the details of the project in the project website or the web page, which will be available in the various web portals of the Real Estate Regulatory Authority. It will be, the project layout will be available, the plan, the various approvals which are given by the planning authority, namely the municipal corporation or the municipality. Then what is the proposed development work? What will be the other facilities and amenities that will be available there, in the sense of whether there is rainwater harvesting or many other things that will be there. The land title report that will be shared so that you can access that. The advocate has signed that to say that yes, the land title is clear, or what are the problems there. If there are encumbrances on the land, that also will be shared. Encumbrance in the sense that if you have mortgaged the land by taking money from a financer, so those encumbrances report will also be shared. Then what are the agreements that the developer would have done with maybe financiers, investors, landowners? So essentially, all this information would be available. So it will be necessary to actually create that awareness in every home buyer, each one of us. In fact, I'm afraid that has not happened. And that is the challenge for RERA, that each one of us, whenever we are intending to buy a home, we should be spending some time going into the project web page to check out all these details and then make an informed choice, and not be swayed by someone saying that why don't you go ahead, he's a reputed builder, go ahead and do that. It also has variety of things like last 5 years, how he has performed, whether there are litigation in the project or not. This information is all available. There are 116 fields of MahaRERA in which information about a project is shared and is available in the public domain. Then there is the assertion on the timely completion of the project. So the timeline by which the project, if there are 2-3 buildings in the project, each building's different timelines, when will they get completed? Then, as I mentioned, litigation details, names, details of the project professionals who will be attached to the project, who is the architect for the project, who is the chartered accountant, who is the engineer, the structural engineer. All those details are available right there in the public domain. So that if suppose you want to reach out to the professionals to find out for yourself as to whether things are happening in the proper manner or not, you can do that. False statements and other things are strict no-no, and in fact have severe penalties prescribed in the act. Then this is another thing that used to happen, that you book for a particular type of a flat and in a particular building with a particular layout, and then everything undergoes a change without your knowledge. Now that is again something which is subject to penalty if the person does without taking the consent If it is your individual flat, then changes in that has to require your consent. If it is changes in the layout, then it requires the consent of 2/3 of the total allottees or the total home buyers in that. Sale agreements also will not be lopsided. They'll be as per a model form of agreement, and that's how it has to be done. And the information that is once shared while a project is being registered will have to be updated every 3 months. Again, this section 11 of the Act puts the onus on the developer that you keep on updating the information on the website so that whenever a person is as already booked into a project, he or she is not required to go to the project site, which may be 40, 50, 100 kilometers away, to check out what is the progress of the work. One should be able to again access the website and see for himself or herself as to whether the project is proceeding in the right direction with the right speed or not. Then there are these things of, as buyers exceed more than 50%, more than 50% people have already bought into the project, then the developers should form their legal entity, which is a proposed cooperative society, moving on to becoming a registered cooperative society. After completion with occupancy certificate, the developer should hand over the project or convey the building to the cooperative society. The building's quality has to be assured in the sense that if there are defects which are structural defects or workmanship defect for 5 long years, even after the building has been taken possession of, then they get covered. And if there are problems, it can be brought to the notice of the regulatory authority. As I mentioned, the fiscal discipline requires 70% of the funds collected from the allottees will have to be deposited in a special account called the RERA account, which account number is also shared and is available in the public domain, from where the monies will be taken out with only certification of the chartered accountant to be utilized for the purpose of the completion of the project. Then, as I mentioned, the last 5 years project things they also have to be shared. The withdrawals will have to be certified by engineers and architects, and the chartered accountant will also certify. Then if things go wrong, if the project is not moving forward and the authority has to take penal action in the sense of revocation of the registration, then there are provisions for that, that special account to be frozen, banks to be informed to see that whatever money is there cannot be taken away by the developer, and then to move ahead to see how the association of allottees, the buyers in the project, will be empowered to go ahead and complete the balance work in the project. Now, basically, this is what, as I mentioned, and as I say that if suppose there are delays, then there are penalties in the sense that you have to pay money for the delay, the interest for the delay. If one wants to actually walk out of the project because there is delay, then you can walk out of the project with interest and compensation. And there are heavy penalties for false or incorrect information. So this essentially, as I mentioned, are the 5 pillars based on which the RERA Act has been formulated. Now, let me quickly run you through some of the things which were the prior preparation that we felt as the MahaRERA team was required if we have to implement an act well. Because it's often said in our country that acts are always very good, but the implementation makes the act look very, very shoddy. Now, we wanted to avoid a shoddy implementation, and therefore, we tried to do things right from the beginning. So as I mentioned, maybe in 2016 itself, Maharashtra government set up this MahaRERA team under me to first go ahead and do the draft rules and regulations, because an act gets implemented by what we call as subordinate legislation, which are the rules, and then the further subordinate ones are called the regulations. So this rules and regulations, the act had already been passed by the parliament, and it had done its own consultation with various stakeholders. So while framing the rules, the Maharashtra government wanted me to also hold extensive consultation with the various stakeholders, the consumer organizations, the developers organizations, the real estate organization. So we held that, and the rules and regulations which come out, I believe the advocates and the legal luminaries say that these are the best set of rules which actually has helped MahaRERA to implement the act correctly. We were very clear right from the beginning that this whole platform through which the Maharashtra RERA should operate should be IT enabled, and therefore it should be a digital platform. because that is where you will stop rent-seeking tendencies. You will also ensure that every information is out in the public domain and it's completely transparent. So there was a knowledge partner and there was an IT partner. The IT partner was, of course, a Maharashtra government TCS joint sector Maha Online. So they together put across this thing by which this digital platform was prepared. Now, for creating awareness among stakeholders, it required that some uh, FAQs had to be put out in the public domain. So FAQs, what should be the FAQs, was also prepared in consultation with the stakeholders, because it is those stakeholders, again, the buyers through their consumer organizations, the real estate agents through their organizations, the developers through their CREDIs, NARUDCOs, and the other MCHIs. Now, through extensive consultation, the questions that they were asked to pose those questions, and those questions were not only answered in the various forum that was attended, but they were put as FAQs in the public domain, so that people who were not a party to those discussions in those public forum would also know that what are the questions that are there in the minds of various stakeholders and what would be the response of the MahaRERA team. Then the outreach programs and the interaction sessions were not confined only to Mumbai. So Mumbai, Navi Mumbai, Pune, Nashik, and all these places, bigger cities where there are a large number of projects. These sessions were held and were held in a manner where online connectivity was provided to the other districts also, so that people who could not attend were also had access to what is the proceeding in such outreach program. It also required a capacity building for the small set of officers and staff which were handpicked to run this MahaRERA organization. And that was necessary because you have to be putting them all on the same platform. The thinking process and everything has to be such that they implement the act in a manner as the team or the leadership wants. And with all these preparations is where we could launch the MahaRERA web portal on the 30th. I give here the website. If people have not visited, it's worth visiting, because there we would like to understand, after visiting this web portal and going into some of these projects which are registered there, one will be able to understand as to what are the information that is available in the public domain. Now, this is something which Smita has already mentioned, so I'll not get into this, though in fact it's a little more updated. Today, there are so many 34 states who have notified, and then there are some regular RERAs, there are some interim RERAs, tribunals have been set up. By large, in fact, if I go to my next slide, this puts out in one slide as to how the implementation of this RERA Act has been, though patchy, but then still, now that we are entering the 5th year of implementation, we find that 94% states have notified, 83 have set up the RERAs, 72% have set up the appellate tribunals, 72% have operationalized web portal. Now, this is something which I would have liked this also to be close to 94, or why not 100%, because the act required every state to put out information in the public domain. So that's how it is. Now, when we see the registration of the projects and agents and complaint disposal, we find that 50% of the total projects in the country that are registered under RERA are from Maharashtra. Now, this shows that the Act has got implemented in a proper manner by bringing in all projects that require to be registered under the Act. They have been registered by and large in Maharashtra. Okay. If in other states the number is so less, then one would say that there would be projects, mainly the legacy projects, the past projects not completed. They have not been brought under the ambit of the Act, and therefore the pain of people in those projects still continue. Now, in the complaint disposal, Uttar Pradesh has done a fantastic job in disposing of maximum number of complaints, because these are mainly the problems of Noida and the NCR region, which fall under the Uttar Pradesh. So this is how the rollout of RERA has been, if one has to see it at a glance. Now, as I mentioned to you, if I have to analyze some of the data which comes out from there, as I mentioned, 30,000 projects registered with MahaRERA out of total 60,000 in the country, implying that the Act is implemented and is bringing under its ambit projects which required to be registered. Now, in these 30,000 projects in MahaRERA, there are 13,000 which are the ongoing projects, which means these are the legacy pre-RERA projects, the unfinished projects, which have been brought under the ambit of the Act in order to see that they should get completed. Now, in 4 years of implementation, what we have seen is that 7,200 and 200 projects have got completed, which means that not only new projects which have been launched post May or July 2017, but even those old projects which were supposed to be completed maybe even prior to 2017 have not got completed totally. The 13,000 projects of the pre-RERA, maybe only 7,000 odd have got completed, which leaves us with good 6,000 projects where maybe problems of liquidity, NBFC problem, COVID fallout in the last 1.5, 2 years, also maybe problems of delinquency of some developers. These are the 6,000 projects which will be a challenge to see how the authorities will get after the buyers in the project to see, empower them to see that these projects get completed if the developers fail in these projects. Now, the 14,000 complaints which are there in MahaRERA, they pertain to 10% of the total registered projects. Now, if there are 30,000 projects, then only in 3,000 projects, the complaints have come in. Now, one could be that in the other 27,000 projects, everything is hunky-dory. The people have no problem. The other thing could be that we are still short of creating the required awareness among all the buyers in the other projects, so that if they have a problem, they should come up either to the conciliatory forum to resolve their problem or file a complaint, the quasi-judicial complaint. Now, this is something which, if suppose the new projects will be about 27,000, 17,000. If the new projects are following and are compliant with the provisions of the Act, then one would say that it's certainly a good thing. And by and large, we can then say that yes, RERA is certainly a game changer in the sense that the developers are behaving much more responsibly in the regulatory regime, and they're ensuring that all the information is being shared with the people and the rules of the game are being complied with. Now, 10,000 complaints have been disposed of, but there are 4,000 pendencies, also a matter of concern, because if suppose complaints that were filed with this expectation that it will have quick redressal, unlike what happens maybe in a consumer court, then I would feel that there has to be tendency to see how further we can quicken this the disposal. The other thing would be certainly here to see how we can create awareness among people to try and see if problems which are faced by the people are first tried out to see whether a conciliation is able to solve the problem. If whoever the 800 odd cases which have come up in conciliation show that 3 out of 4 get successfully resolved, then I'm sure that these 4,000 cases which are pending, had they first gone to conciliation, then maybe 3,000 of them would have been resolved by now. And only 1,000 would have been required to be doing a quasi-judicial redressal. I'll quickly also mention some of these things. I think I'll take another 5 minutes to complete my talk so that you get adequate time to have further interaction with me. As I mentioned that this participative and digital governance is something that MahaRERA did. So today, MahaRERA is the only RERA authority which has an ISO certification. It's a 100% digital platform with every information there is available, and every service that is provided by MahaRERA is all digital. Even hearing processes are digital, and certainly the registration and other things are digital. And you'll be surprised to know that this extent of work that MahaRERA does, 30,000 project registration, 30,000 agent registration, 15,000 complaints being handled, about 1,000 conciliations being handled, all is being done by less than 50 people who are working as a team MahaRERA. Now that is possible only because this whole thing is digital. The conciliation and dispute resolution, it requires maybe one full session to discuss as to how this is performed and how it is functioning very well. The simple bottom line is that it is something which is something that other states are now seeing that yes, it's a replicable model, and they are also, UP has already gone ahead, Karnataka is doing it, Many more states are wanting that they go into this. And it makes me very happy because this is something which I feel will build trust and it will bridge the trust deficit. Quality certification is another new thing that MahaRERA felt that if a person puts in his life savings to buying a home, he should also feel assured that the quality of the home is well. So it is trying to make the engineer of the site accountable to ensure that all the raw material and the processes that are being followed are being done in a manner which are in conformity with the various building norms that are there, the building codes that are there in the country. Skill development is another thing that was started to ensure that the workers who work on this set are also passed through a certain certification program, so that again it assures that not only the raw material is good, but people who convert the raw material to finished product are also having a certain level of competence to see that the quality of the product, finished product, which is the home, is good. Self-regulatory organization was another innovative thing that was started on MahaRERA, because it was seen that there are 30,000 projects, but all these projects are belonging to mostly members of these organizations like Naredco and CREDAI and the MCHI. It was felt that if there are even smaller organizations who have certain members, it should be ensured that these organizations' members are the ones the organization should get a self-regulation or regulatory organization certificate from MahaRERA, so that MahaRERA through these self-regulatory organizations are able to convey to the various members to be more professionally approached, to follow, enforce the code of conduct, so that there is least amount of fraudulent practice among promoters, because then you also hold this the self-regulatory organization whose member may be indulging in some sort of unsavory or a fraudulent practice, hold him also to task. Another effort towards making these organizations more accountable. Now, coming to my last slide, what would be the challenges in the post-RERA era? The first, of course, as I mentioned, is creating general awareness about RERA. People, I'm afraid, even in fact, the other day I was maybe 6 months back, I had gone to my bank, and the bank manager, knowing that, yes, I was chairman of MahaRERA 6 months or a year back, he said that, sir, I'm buying a home. And then I asked him, have you visited the website? Have you checked for yourself? What is the home you are buying? And he was not aware that there is a MahaRERA web portal where all this information about the land title, the encumbrance, the litigation, all the various things that I mentioned are all available there. So basically, how do we ensure that anyone who is thinking of buying a home, intending to buy, actually goes, visits this website, and then finds out for himself and makes himself an empowered person to make an informed choice. So creating that awareness is something which I would feel, and it's not merely because the awareness today is that, yes, if I'm buying a home, it has to be in a RERA registered project. That's not the that's not the only thing that you're required to do. If it is a RERA registered project, then there is a RERA number. With that RERA number, you need to go into the website. You need to open the web page. You need to see the various parameters of the project and then decide. So that level of awareness, how do we reach, is a challenge. Effective and uniform rollout across the states is certainly a challenge, as I mentioned. Now, how does it happen? It should have happened. There has to be effort made by, there is already a forum created of these RERAs called the I4RERA, All India Forum of RERA. I'm sure they would get after the laggard states to see that it's a uniform rollout. There has been also problem of certain orders passed, especially orders of refund of money, which have not got executed. Now that also is related to a certain extent, the COVID problem and the liquidity problem. But then there is no excuse for that. If a quasi-judicial order is passed, it has to be executed. So how do we ensure that the orders that have been passed get executed? As I mentioned, dealing with the legacy issues of pre-RERA projects, if out of 13,000, only 7,000 have got completed, 6,000 need to be completed. So there will be pain of transition. There will be certain things like maybe they have got stalled, they become a stress project. So how do you ensure that these projects get completed? Then there are other acts also operating in the country, like the SARFAESI Act, the Insolvency and Bankruptcy Code, the Debt Recovery Tribunal, the Maharashtra Protection of Interest of Depositors. So various acts also function and it confuses maybe a home buyer who, when in distress, does not know where should I go. Now, it is felt that if for this sector there is a regulator in place, then that regulator should get precedence in trying to see whether a problem that has come up gets resolved first. And if it is not resolved, then go into insolvency and other things. And as I mentioned, bringing all of the stakeholders so that the accountability is uniformly applied to all stakeholders in a project when there is something where a regulator would like to ensure that the project has to be taken out of a stress or when it is stalled. Otherwise, the highly decentralized operation, though it was an unregulated sector for 70 years, mere bringing in regulation will not overnight change and make every developer in the sector as a professional player. That will also be a slow process, but then that has to be quickened to see that every player, only professional players who are developers survive in this. No fly-by-night operator or someone who just come forward to say that I have land, I want to become a developer, should become a developer. And even if he becomes a developer, there should be certain awareness among people to see that they just not go ahead and get swayed by maybe faulty advertisements or other things by which he is trying to attract people. Inadequacy of affordable housing still remains, though I must mention here that about 2 years back, when I was assessing the total number of projects that are there, these 30,000 projects will bring in about 100 units per project. So therefore, 30 lakh homes are registered in these 30,000 projects. 60%, if not little more than that, were all affordable housing units, in the sense that they were 1 BHK, maximum 2 BHK. Now, this was happening because the Pradhan Mantri Awas Yojana's interest subvention and other subsidies that were available, they were dovetailed with some of these projects, and therefore the projects, especially in the outside of the metropolitan cities, were smaller homes which were priced less and were getting into the affordable housing segment. So I would feel not only these, but even the MHADAs and the municipal corporations who are taking up affordable housing projects to take it up in large scale, so that at least this inadequacy of affordable housing is tackled. Approval process still remains a problem in the sector because that is still non-transparent and in fact lacks accountability of those people who sit over projects and don't give approvals or delay the whole process. So that is another thing that is very important in this. Speeding up and regulating brownfield projects, because as cities grow old, urban renewal is something that has to be taken up. Apart from slum redevelopment, there are cess buildings redevelopment, society redevelopments. All such redevelopment projects should also be brought under the ambit of this act, so that at least those projects, when they are taken up, there also there is accountability among the developers. Delays in project completion I have already mentioned. And if suppose these projects are not properly done, in the sense that they still continue to bring out homes which are not in accordance with the demand, then there'll be no buyers in that project, and that will further lead to liquidity problem in the project and not allow the project to get completed. So professionalism will require people to go back to the drawing board and come up with such projects for which there are takers. As I mentioned, if 60% and more were 1 BHK, it is because there was realization in the developers that they need to enter this space where they bring out these homes which are affordable to a large number of people, and therefore those homes will sell. So I think this professionalism over a period of time will help the sector. Overall, I must say that yes, RERA is certainly a game changer, and MahaRERA has certainly shown the way as to how a good act, if this is properly implemented, can become even better. Thank you.
Thank you, Mr. Chatterjee. Thank you so much. I had actually planned that I would show a few slides for people who are unfamiliar, but as you assured, I think your talk was so appealing. And of course, I think with the rare, I would say, case of IS trader who has been allowed to specialize, and you have ensured that you specialize, you carry such a deep, extensive and in-depth knowledge of the housing sector, and you have always been a people's officer. Uh, and I think that perspective as well as that knowledge is very, very deeply reflected in your talk. And I think that's why one has questions. So just scanning through the questions, I think all of these questions in some ways illustrate that your talk has been comprehended by most people. So I will go to the questions right away, perhaps. Okay. My own questions, perhaps I can also take towards the end, right?
Sure.
And so I'll come to this question really of Arkaja from CPR. And Arkaja, you can see this in the chat box as well, Mr. Chatterjee. But Arkaja asked that she thinks of RERA powers in terms of a regulatory pyramid on a sliding scale, in which the regulator can move between less and more coercive punitive instruments. Would you be able to say a little more about how the different powers and roles are interrelated or mutually reinforcing or not? And perhaps I would just add a little bit to the question in the sense that if you can also talk.
Simplify the question.
Uh,
Yes.
No, I think that regulation can have different things in terms of facilitative regulation to thinking about highly punitive regulation. And
Okay,
if one,
I thought I
yeah,
had mentioned that in my talk, but then
yeah,
I'll certainly explain that.
yeah,
You see, that is where I say that there is a proper implementation of the Act by MahaRERA by bringing out those innovative things there. Now, those innovative things are not something which has to do anything with anything punitive. Those are things where you are, when you are setting out authority which is 100% digital, you are actually ensuring that there is no rent seeking. There is no compliance cost. The cost of transaction, in fact, is minimized. So this is all is something trying to facilitate the developer, who in fact may be always feeling that he has to run from pillar to post, get his project approved. He doesn't have to do anything in order to register his project. He has to only be truthful in trying to share every information in the website, trying to tell him that he should have the project done in a manner where there is no mismatch between supply and demand, is something, is again trying to bring professional in the sector, trying to tell them that please ensure quality in the project, so that at least in the next 5 years, when a defect liability complaint comes up, you don't have to face a problem. Is again, prevention is better than cure. Now, these are all facilitating measures, trying to tell them that rather than fighting it out in like in a courtroom, like in a quasi-judicial, if you are able to sit across with him, talk to him, and then through a conciliation, trying to resolve the problem in a project, is again an issue which is a facilitating thing, trying to tell them that no, it is not only penalizing you that is going to take you. And that is when I said that when we talk in this language, that is when 13,000 old projects in Maharashtra get registered in MahaRERA, whereas in across the country, not even 2,000 old projects get registered. Why? Because you tell them that I'm registering the project not to see that if you go wrong, I'll penalize you. You are registering the project to tell him that if you have a problem in completing the project, there is now a regulator standing beside you to see how the project gets completed. So that is how I think it's the approach with which the act has been rolled out in Maharashtra. Is certainly the development has been given more emphasis along with regulation. So it is Regulation and Development Act. It is RERDA. The D has been given stress.
thank you for that. There is another two questions which I'm combining. So this is from Bhupender Vashish, and who basically asks the, especially in the concerns of developers in terms of acts of God outside their control and which may cause delay in projects. So how does the RERA perceive and protect this particular incident in case of developers?
See, act of God is what is called as force majeure. And it is also captured in the Act, Section 6 of the Act. And it has been also utilized in this act of God, which was the COVID-19. Not only a 6 month type of a moratorium was applied, later on, the present dispensation has again applied it for another 6 months. So basically, for acts of God or force majeure, there are provisions in the Act which are also being utilized. But it does not stop there. What I am trying to explain is that it's not only acts of God, there are acts of other demigods sitting in the municipal bodies who actually ensure that the concern of the developer is further making them more concerned. We are saying that even those are the areas which the act should go into to see that it deals with the concerns of the developers. So I have a feeling that Mr. Bhupinder Vashisht should try and understand that there are various acts which are being carried out by the RERAs, at least in MahaRERA, which is trying to tell the developers that we are also standing by you as long as you are true and you are actually compliant with the act to see that the project gets completed. So it is the project, its completion, that is the priority. Whether it is had to, and for that matter, let me also share one experience. In one such case, a project which was physically completed, and there were buyers coming forward to say, sir, we are not taking possession. And when it was being heard, my colleague was hearing the matter. He asked the developer said, sir, I have done everything. The architect is also present. He says, I have completed the project and I have applied 3 months back to the municipal body to get my occupancy certificate. I cannot hand over the project unless I have the occupancy. My colleague summoned the concerned engineer of that department to come forward to explain that what is the difficulty, why is he not issuing occupancy certificate. And you won't believe me, on the next date of hearing, the person turns up with the occupancy certificate. So this is actually also concerns of developers which are being looked into.
Thank you. There are another set of 2-3 questions which talk about specifically clientele of or customers of housing who are semi-literate, who include many people among the informal sector and who may definitely not be aware of several of the provisions. I mean, you talked about the banker who was not aware of RERA, but does the RERA specifically carry out campaigns or make an effort to reach out information to them about what are their rights and how to secure them under the RERA or other kinds?
I'm afraid it has still not done in the manner which the Act requires it to do. Section 33 of the Act actually puts the onus on the RERA authorities also to create awareness. And I would certainly feel, and I had mentioned also, because my first 3.5 years when I was there, we were trying to put it in place. But now is the time when we have to reach out, especially to the vulnerable group, who may not have
add
access.
something, Amita?
Yeah, you want to hear his answer first, perhaps?
Yeah, shall I add to that question which I had asked?
But let him complete his response, Sachin.
Yeah.
Especially the vulnerable group, yes. So how does that create the awareness get created? How do we utilize bodies like Ts? How do we utilize bodies like the consumer forums, the Mumbai Grahak Panchayat, or any other innovative method by which we can reach out to them? And as far as the digital literacy or illiteracy is concerned, I don't think that should be a problem even for the person staying in a slum or otherwise who is not at all having his own setup or a computer. There are methods by which he can have access from where he should be able to access. The whole point is to try and create that awareness. That is an area which I think is a challenge and we need to look into.
Okay.
Sachin,
Sachin, now you can add.
So under that section 33, as you said rightly, for example, we are looking at across sectors also, like electricity has a consumer representative mechanism, so which focuses largely on the smaller, like agriculture consumers and all that. So can there be a possibility to create a consumer representative office or something which looks into the smaller consumers within RERA? It's like a public advocate office, which is often used in.
No, I'm not confining only to that point. What I'm trying to say is section 33 is so elaborate. One can use every mechanism that is possible as long as the thing that you're trying to achieve can be achieved. One should go ahead. Whether it is using the multimedia forum, using the consumer forum. In fact, already discussion has started with the Mumbai Grahak Panchayat to see who are already there in the electricity regulatory thing. So they are already very much active in the conciliatory mechanism that we have. But in the awareness creation, they are very much keen that yes, it should be done. In what manner, how it can be done, I'm sure people like you can actually put in suggestions to the present MahaRERA setup, and they would certainly be very, very happy to take it forward.
Yeah.
Thank you. Uh, I think there is another very interesting question, and which is from Sonia Singh, and who asks, are there any connections between disparities in development in different states and the RERA Act implementation? I'm also taking this question to perhaps interpret this as the state of the housing and the real estate market all across the country is also extremely diverse. So, for example, if we look at Maharashtra and Uttar Pradesh and Odisha, and I think one will come across certain significant diversity. So is this something in your view is linked to RERA Act implementation, or are there other factors?
No. Point here is that the act is a central act. So one would tend to think that one is trying to straitjacket it to think that across the country everything is similar and therefore one central act can take care of everything. But then the act also has these rules to be framed by the respective states. It also has the respective authorities will frame regulations. And it is the act read with the rules and the regulations that implements the act. So I'm 100% sure that whatever is the situation in that particular state will be taken into note of in framing of the rules and the regulations to ensure that this happens. The bottom line here is that whenever there is a private or a public authority included, who is constructing homes for sale, the only point is that it is only talking today of ownership housing, not the rental. They will have to now think about maybe the same regulator looking into rental housing also, because affordable rental housing is also coming up in a big way. But then today, if any public or private authority is constructing homes for sale, and if it is more than 500 square meters or more than 8 units, then he must register himself and put out information in the public domain. Now, there cannot be anything which is differing from Bihar to Maharashtra when one says put out. Now, what is the information that will be put out in the public domain will be guided by the rules and the regulation. Maharashtra has 116 fields. Bihar may decide, no, it is only 60 fields that will be necessary. There are certain mandatory fields, but there are certain other things that Maharashtra has added. Now, Bihar may not add, Odisha may not add. So, therefore, those things are inbuilt in the implementation of the act.
You talked about the public authority just now.
Yeah.
So Sachin had another question, and which perhaps one could extend to looking at public authority. So he says, instead of SRA, should we have a RERA like autonomous regulator for either slum rehab projects or other public housing projects?
No, let's not mix up an authority like SRA with an authority like RERA. SRA is an extension of the Mumbai Municipal Corporation. So SRA is a planning authority, though it does not do any planning. That's a part. Okay, now it is supposed to do planning. It is actually supposed to see and plan out where are slums, how much land is the slum. When we are redeveloping the slums, are we actually selling out everything to a private developer, or are we ensuring that over a period of time it will get developed? No, these are aspects of planning which are not being done. So I think a planning authority's function is what is defined in the Act as a competent authority. So RERA does not replace SRA, but then whatever plans and other things are approved by SRA, when I said that brownfield projects should also come under the ambit of the Act, it is saying that projects approved by RERA or SRA or by MCGM, either cess building redevelopment or slum redevelopment, all such projects should come under the ambit of the Act. If it comes under the ambit of the Act, the bottom line is that every such project will have a stipulated timeline. The problem that is faced today in every redevelopment, including slum, is unending project. It never ends. For 15, 20 years, it's continuing. Now that has to come to an end.
Yeah. So we have one more question, and which is perhaps a little qualitative, and thinking you about, suppose one were to evaluate RERA's efficacy. You spoke a lot about trust. How would we define trust? How would one measure trust?
No, trust's measure is by the result. The point is that the stakeholders in the project needs to trust the regulator. The stakeholders inter se should trust each other. Now, whether that trust is happening or not is the measure of that comes from the variety of things that are there in the result. For example, as I mentioned, people have problems, umpteen number of problems people had. These 800 cases which came up in conciliation, which were facilitated by a member of the Mumbai Grahak Panchayat, a member of the developer sitting as a conciliator, who were adequately also trained by MahaRERA. A lot of effort has gone into that to ensure that these two warring people start discussing. You see, initially what was the report coming up is, I have never seen this developer's face in my life. I have spent 40 lakhs to buy my home. This person never cared to actually tell me that he is the developer. I have been only meeting that person down there in the project site who doesn't talk properly. So it is that itself, the buyer started feeling that, yes, I am now on a level playing field. I'm no longer somewhere here and the developer is somewhere there, and then I'm talking to him like that. We are now talking on equal terms. I felt that is the real groundwork created for conciliation and mediation to happen, and it's therefore started happening. If 75% conciliation results in successful conciliation, then I think, yes, we are building trust. Similarly, here developers look upon authorities with suspicion. Now, they are the SRA authorities or the planning authorities, the BMC. There is a lot of rent seeking. We all know about that. Now, how do you take them to a situation where it's actually a faceless administration? In MahaRERA, people in Sangli, Solapur, they did not know as to where MahaRERA office is and who are the people who are. He is able to track his information when he files an application and sees how his application is moving, so it goes up to the registration stage and gets registration done. And a digitally signed certificate is delivered on his laptop. So these are things which are essential ingredients of building trust. And I think if that happens, then one can actually put a TISS survey to find out whether trust is happening or building or not.
Another colleague of mine asks, especially about your thinking, and not just your thinking, but perhaps other people who were involved in thinking this through along with you, Mr. Chatterjee, about this people-centered approach that the MahaRERA has taken in this case. Why did you think about this the way you thought? What was the opposition to it? Was there any opposition?
Frankly speaking, there was absolutely no opposition.
What were the tensions which were generated?
No, in fact, the amount of tension I have gone through in my various avatars in CU SRA or CU MAHDA, or maybe even earlier in various other things, or additional commissioner of BMC, here I had an absolute helping hand in the chief minister then, Devendra Fadnavis, who gave me a free hand to set up this authority. But then only thing he had said is that Maharashtra is 100% a digital state. Therefore, please set up something which will be digital. There was absolutely no interference, no nothing. And fortunately, it was a good act where, in fact, if you see, the provision of the act is very clear that it is the centricity is on the consumer. So basically, it has to deliver on that front. So I don't think there was any problem at all. And this regulatory mechanism with total autonomy, because we did not also take a single pie from the government, state government, in order to set up this authority. So it is financially self-sufficient, it is a fully autonomous body, and it has been able to perform it that way without any political or other interference.
I'll take this to another question, and which had appeared, something that Ratula had asked. And I think we are all aware of the fact the developer and the construction industry itself is not uniform at all. And while today there are many, many large, even perhaps interstate and global players, there are many housing constructions which happen by little more than perhaps contractors. So their modes of advertising are different, their modes of operation are different. They perhaps involve very different kind of knowledges. And okay, have there been any specific challenges that such small players have faced, and have there been any efforts to outreach them? And can you think of any other ways in which they can be included? because I think keeping the small player in, our studies actually show that most affordable housing, not defined as such, okay, the defined affordable housing often ceases to be affordable. But the undefined affordable housing is in fact constructed by these smaller players.
Absolutely. Absolutely. No, you have absolutely hit on the nail on the head. Uh, tier 2, tier 3 cities, where the real areas, which in fact uh, all of us in the urban space should look forward to ensure that they do not turn out to be another city with maybe 30-40% slums. So those are the areas where these small contractor turned developer or whatever had to be reached. So we were fortunate in Maharashtra to have a very wide network of such smaller players also as members of this CREDAI Maharashtra or NAREDCO, these two bodies. Plus, there were also, when we started this concept, the concept of SRO stems from this only. In the SRO, what did we say? Because initially, when we did this analysis of the data, at that time, we had, say, about 16, 17,000 total projects registered. I'm talking about when we are thinking about SRO. Out of those 17,000 projects, we found that hardly 2,000 projects are done by members of these bodies like NAREDCO and CREDAI, which means the other 15,000 are being done by standalone people, what you mentioned as maybe small contractors or small bodies. No, they are also doing a good job. They have small establishments, so their costs are also low. They are able to actually reach out to, may not be the poorest of the poor, but then certainly in the EWS, LIG sections. Now, they need to be also brought into the ambit of professionalism. They should also learn little bit of professionalism as to what is required. So they should not get caught. They should not get caught unaware of some non-compliance in the RERA Act, so they have to be penalized. In order to ensure that, we then shared all the information of the projects which are registered by members who are not members of these bodies with all these SROs, telling them that you reach out to them through your district units. We also mentioned to them that you have very high threshold for making a person a member. You charge 25,000 rupees for a developer to become a member. How will this small player become? He maybe is doing one small home in a small plot of land, maybe only 10 homes he's constructing. We brought it down to only 1,000 or 2,000 rupees, saying that you need not give him a full membership. Have some concept of a RERA membership. You are giving him this membership to ensure that he has access to the digital thing. He has access to little bit of training that you will give him. And that really worked. So basically, we had this in mind and we wanted, and I hold this view that it is not the large multinational or the big players who is going to actually survive in this RERA thing. My viewpoint here is, and mark my words, that small is beautiful and it will continue to be beautiful. And you will have smaller professional players, maybe small architects, chartered accountants, who maybe has access to talking to a landowner, developing a joint developmentship of the land, and coming up by knowing the provisions of the act and doing a project in a very timely manner. So that's I think will be the future of projects, not maybe in a cost exploding cost in Mumbai, but then I'm talking about the distant MMR region, PMR region, or maybe even the other district places.
I think that's a very interesting point and tracing of the future that you're drawing, very hopeful as well. And coming to that point of hope, I wanted to add in one reflection and question of mine, and which is that today, I think if we take a look at the housing sector as a whole and not just look at the organized part of the housing sector, then one understands that the housing sector requires multiple kinds of reforms, perhaps, in order to be relevant to the needs of people, person, right? So where would you, so RERA in that sense comes as a set of reforms, or it should come in as a set of reforms. Any reflections on that, and whether those also are coming or are in the pipeline? Or do you think, and RERA in isolation, what can be both the limits of the impact of RERA on the housing sector and the potentials as well.
I will take you back to one point which I mentioned, that fortunately the Act created this authority, and the authority wears three hats. One is the administrative part of how the RERA will actually do the registration, do blah, blah, blah. The quasi-judicial of where you try to resolve the problems that are there, the grievances that are. The third is the advisory role to the government. Now, unfortunately, the government, which actually should seek advice of this regulator to see as to how do we resolve this crisis or this problem in the housing sector that is there, that has not happened. And I would feel, since that role is already mentioned in the Act, it is up to activists, it's up to educational institutions to try and bridge this gap between the government and the authority, to prevail upon the government to see that, yes, advice is sought from the RERA authority, to see that these anomalies in the housing sector is resolved. Because otherwise, you will be actually, you have rightly said, you cannot only go ahead with this ownership housing, resolving the problem of a few. You have a large section of people in the brownfield. Majority of these cities are getting old. 70 to 80% of Mumbai is either Maharashtra's old colonies, SRAs, the slums, the cest buildings, the old society buildings. Now, if you do not have a proper policy in place for them, you cannot only just sit there and keep on increasing the size of the free housing to say, no, 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 everything is hunky-dory. You give him 270, no, give him 300, no, give him 500 in BDD Chawl. Where will that free housing come from? It is from your and my pocket. It has to come from the free sale component. So nothing is going to happen there. So these policies, which will ensure that the scale is achieved and we are able to tackle this larger problem, will have to happen. But then RERA can play a role, as I mentioned to you, because there is this advisory role. But then someone will have to then tell the government that in your thinking process, why don't you actually pose this problem to RERA and let RERA come up there? RERA will then get out to consumer bodies, to TIS, to other bodies who can then tell as to what should be the thing, and then a proper policy will come into place. But this is how I feel this can be resolved.
But honestly, do you see any prospects of that given the current political economy of housing itself, the way in which
I'm an optimist. I don't lose hope. I know this is in the current scenario, it is not going to happen. But then what I'm trying to say is that I always say this, chor chor mausera bhai is always there. But the good people never join hands to see how do we take it forward.
Okay.
The time has come when good people need to join hands to see that, yes, let us do some good in this. Otherwise, in fact, things will go from bad to worse.
Okay.
Let's do that.
And thanks for such a hopeful statement. I'm going to very briefly, perhaps, Ratula, I hope we have time for opening this up where directly people can ask questions or any reflections, comments.
Yes, we
Sure,
do.
I think
We
can.
have some time.
Yeah, okay. So we can take about 2 or 3 if
Yes.
anybody wants to comment, reflect, ask.
Sure, go ahead.
Yeah, hi. Shall I go ahead? I have a question on.
Yeah, please go ahead.
Yeah, sir, it was very nice to understand how RERA has come up and what it took for you to actually give a lot of teeth to the Act and its implementation. But the more I read about the Act and the RERA authority's power, I see that it is not going into the economic regulation of the projects. For example, you have an escrow account, which is a very important regulation that has come.
Not escrow, separate account.
Yeah,
it's not escrowed, but it is a separate account. Yes.
Okay, but then who regulates that and who monitors that? Whether actually
No, the Act is based on.
Can
not,
RERA take up some role in that?
No, again, let me explain this. The Act does not require the RERA authority to do a micromanagement of everything. The Act has said that there will be these 3 sets of professionals: the architect, the engineer, a chartered accountant, and another set of chartered accountant who will do accounting of that RERA account. He's the annual account auditing has to be done by a separate chartered accountant. So basically, the Act says that these sets of professionals should act professionally. They should not act as like their employer says that, no, you sign on the dotted line. That is what is expected. And there is again accountability for them. If the RERA authority comes and it comes to the notice of the RERA authority that one of the professional has not behaved in a professional manner as is expected, then there are serious penalties. The Maharashtra RERA rules mention about that.
Okay, then RERA can intervene. Yeah.
Yes, that is how I also feel that that's the correct thing to do, rather than, because what happens is any public authority, if you make him do micromanagement, it only breeds corruption and brings in
Corruption.
rent
Rent
seeking.
seeking. Yeah.
Okay,
Correct.
so therefore I feel that it's a very good aspect that this act has brought in, and we have also understood that aspect in the right spirit and implemented the act in that manner.
Okay, thank you.
I see Mr. Fatak here. Mr. Fatak, do you want to say anything?
Vidyadharji.
Yeah.
He can certainly enlighten us with his, he's
Yeah.
one of the persons I look upon as the knowledge
Absolutely.
Pandar.
Ah,
Maybe
I
he
think
can
he has
unmute
left.
himself. Or has he left? Yes.
I think so. I think he has left. Okay. Any other question?
Any question from one of those people who do not belong to the two schools that you mentioned?
There are several.
Any other questions?
They must ask a question for me to understand whether whatever I have said have actually they have understood or not.
Amita, may I ask another question if we have
Yeah,
time?
please go ahead, Arkaja.
Hello, Mr. Chatterjee.
Yeah.
You reflected briefly on this. I mean, something you said in response to one of the questions, which was very interesting, about interference and the fact that your role in RERA was probably one of the most, the most stress-free from that perspective compared to some of the other far more, complicated profiles like being in the BMC. And so I was, I was wondering whether you could reflect a little more on what so the aspects of RERA as a regulatory authority, which make that difference. So one of the things is that having been in the service, having been in the state government, obviously, so there are two aspects of this. One is that having been in the state government, obviously makes, would have made you more effective in RERA, because there are many things you know about the state. Your orders would be recognized by other officials in the state government or in any of the other planning and approval agencies. So there's that form of mutual recognition and respect for hierarchy, which would, which is something you carry into this role. But the other thing that is distinctly different about the position of RERA is the recruitment procedure and the fixed tenure, and also the fact.
Well, I have understood your question. Let me answer. Otherwise, I'll forget as to what is the question you are asking.
Sure.
Okay. You see, point is the most important difference is that in those 33 years, I was a government servant. Thereafter, I was a regulator. So essentially, there is a difference between being government and being a regulator. Here, when you are a regulator, as an autonomous regulator, it makes tremendous amount of difference. Number two, you use the word hierarchy. The respect of hierarchy is one thing, but the hierarchy is a double-edged sword. While you have people below you, you feel that, yes, I am sitting on piles of people who are actually showing me respect. You are also there, a cog in the wheel. There are other levels above you also, which actually creates this problem, which I mentioned, that in government, there are too many authorities above your head also. And then you have tremendous amount of sort of a tightrope walk to do when you actually have to implement something which you feel your conscience says that, no, this is the way it has to be done. Okay. You have to implement a policy which has been made, where you try to put in a policy which is something which is implementable, but then you have been told by the bosses that no, the policy has to be this way. And that policy, once it's approved, then we, as a government, your code of service conduct rules require you to abide by that and implement that policy, even if your conscience says that, no, this policy is faulty. In a regulatory job, you have the total authority to put in place the policy which you feel that, yes, this is, and there is no one who is going to question that in the hierarchical setup. So this is a tremendous amount of difference.
Thanks, that was very useful.
No, I'm just asking you, this is theoretically, Mr. Chatterjee, definitely the business of regulation. But I think the regulatory authorities in India per se, I'm not just talking of the real estate regulatory authority, but they are working in a highly politically embedded, porous kind of an environment where constantly their decisions and the overall environment within which things are happening
You
is
need to
political.
have a
Do you
selection
think
process
you can
where you
stay
have
away from that politics?
the selection process has to be such that it is insulated from that sort of a thing,
Mhm.
where you do not have your crony to be sitting there in that chair of a regulator. If you have created autonomous bodies called regulatory bodies, they will succeed only when you have to do that, when you can do that. In the RERA Act, you have provided for a setup where this selection process is under the Chief Justice. It's a committee headed by the Chief Justice which decides on who should be the chairman and the members. Okay. Now, similarly, you will have to bring in such mechanism by which you get the right person for the right job. Then only regulatory mechanism will actually succeed. Otherwise, I agree, it will become an extension of what the officer did for 33 years. He is expected to continue that doing there and toe the line of the boss.
And
That's
in
not
your
what is expected.
assessment within the country,
Yeah.
To what degree are real estate regulators and RERAs
No, real
insulated
estate
in this manner?
regulators, by and large, as I mentioned, because the selection process in the Act has been done in a manner where it is maybe an interim regulator could have been appointed by the political powers. But otherwise, the appointment has been vetted by a committee headed by the Chief Justice of the state. And if suppose that recommendation of the Chief Justice Committee has to be set aside by the political dispensation, they will have to give also reasons for that. But to my mind, I don't think it has happened so that anywhere it has been turned. I'm not aware of that. But then if that happens, then in fact, we have RTI and other things. And people to then question the government as to why did you overturn a decision taken by the Chief Justice.
Okay. Thanks for that very interesting and frank answer. There's one more question which I believe you've at least responded partly to earlier, but let me ask it and you can think about whether you want to respond. Aydin Jaws says real estate developers are understood to be part of a nexus with political leaders. What has RERA done to this relationship?
So that would be a very sweeping statement. Essentially, basically, everyone is politically inclined, and for real estate development, which in fact remained unregulated, where there was a whole lot of black money and other things that actually was running this thing. So a lot of money's unaccounted wealth was being parked also here. So there was this unholy nexus, which certainly over a period of time with this transparency and this regulatory mechanism in place. And as I mentioned, if we have smaller players who are professional in their approach, who come forward and start taking up projects at much lesser cost, they should be able to deliver much better. So that is one should look forward to. I don't think we should get swayed by that the total political funding comes from this sector. Political funding comes from every industry. And this industry was known for that because of the black money and other things. So transparency, I think, is going to bring down those tendencies. Let's hope for the best.
Thank you so much. I think we've responded very, very adequately, I think, to all of the questions. I will quickly hand this over to perhaps Ratula.
Shubham Kothari has raised hand.
Okay, Shubham, go ahead. And that will be the last question, perhaps. And then I hand over to Ratula.
Just had a question on, has there been any analysis done or is there a methodology to analyze the complaints that are received on RERA, particularly looking at the number of complaints registered against state constructed housing, MahaRERA, then also against SRA, and then completely privately constructed. And is there an analysis like that done?
No, the analysis is not in that manner. In fact, to my understanding, SRA and the other brownfield projects, somehow the redevelopment portion is not covered under the ambit of the Act. So they do not get covered. Though in the SRA, the free sale component, those houses which are up for sale, they are covered under this Act. There were complaints, especially in some of these projects where monies were collected and the projects never took shape, in the sense that the rehab portion got stuck because some developers did not move out and things like that. MADA, we had a few complaints, but then the analysis was that majority of these complaints, as I say, I don't know whether I mentioned, 94% of the total 14,000 complaints are pertaining to these legacy projects, those projects which were of the past, and they are essentially of the type that there is delay in the project. So majority of these complaints are from the projects which are earlier projects, but then that too, it's only pertaining to 2,000 to 3,000 projects out of the 30,000 projects.
Okay. Oh, thank you.
Pratula?
Yes. Thank you so much for that really, really interesting talk and for taking on all of our questions so well and sort of elaborating on them. We hope to have you on board, if you ever get into, discussing RERA or doing an analysis or study in the future. So we
Any
would
housing
really
matter,
like,
not only RERA. Don't
yes,
confine me only RERA.
absolutely. My bad. My bad. Any housing matter to pick your
Any
brain.
housing and urban matter.
Totally, to pick your brains because of the kind of deep experience that
I
you
would
have
look
and the
forward,
knowledge that you have. So we look at this as a start of a relationship with you. Amita has always been there. She's known your work, but we hope that you will continue to bless our center so we can go forward with the studies that we do. To the audience, this talk is also being recorded, so it will be available in 2 weeks' time in our YouTube channel. So if anybody wants to go back and revisit some of these questions and answers as well as the talk itself, it will be available to you. So with that, thank you so much for joining in, everyone. And goodbye. Do join us for the next talk whenever we have that, maybe a month from now. Thank you so much
Thank
again.
you, Nikhil.
Thank you, Smita. Thank you, Amita, for this. And yes, and we all hope to see you over for the next talks also.
And thanks so much, Mr. Chatterjee. Honestly.
Yeah,
Yes.
thank you. Thanks a
It
lot.
was a pleasure working with you because you had the presentation brought to us early on. And, we could even look through the presentation. So everything was perfect. Thank you so much.